Assalamu alaikum, sir. Thank you for giving us the opportunity to speak. Our group is F, and our presentation topic is Treaties as a Source of General Rules of International Law. I am Lisanur Oishi. I will start from the introduction. At first, under international law, a treaty is any legally binding agreement between states or countries. A treaty is a formal, legally binding written agreement between actors in international law. It usually entered into by sovereign states and international organizations, but can sometimes include individuals, business entities, and other legal persons. A treaty can be called convention or a protocol or a pact or an accord, etc. International treaties occupy the same significant position in the field of international law as the legislation occupies in the municipal law. Unlike municipal law, the various methods by which rights and duties may have be created in international law are relatively unsophisticated. States transact a vast amount of work by using the device of treaty. For instance, wars will be terminated, disputes settled, territory acquired, special interest determined, alliance established, and international organization created, all by means of treaties. They maintain stability and diplomatic relation between the states. They are thus the most important elements to guarantee international cooperation, peace, and security. This is one of the reasons why treaties are regarded as fundamental source of international law. That's all for me. Our next group member will continue from this. Thank you.
Assalamu alaikum, sir. My name is Muhammad Rifa Sadia Shoshi. Thank you for giving me this opportunity to speak. My topic name is which treaties are considered as a source of international law. Treaties and conventions are the persuasive source of international law or are considered as hard law. They are a source of obligation for the parties to them. Article 38, Article 1, Clause A of the ICG statute, which uses the term international convention, concentrated upon trade as a source of international obligation, but also acknowledges the possibility of a state explicitly accepting the obligation of a treaty to which is not formally a party. Some treaties are the result of codifying existing customary law, such as law governing the global commons and jus ad bellum, while the purpose to establish a code of general application. Its effectiveness depends upon the number of states that ratify or access to the particular convention. Relatively few such instruments have a sufficient number of parties to be regarded as an international law in their own rights. The most obvious example is the 1949 Geneva Convention for the Protection of War Victims. When the treaty rules reproduce an existing rule of customary law, the rule will be clarified in terms of treaty provision. A notable example is the Vienna Convention on the Law of Treaties 1969. Pursuant to the Chapter 16, Article 103 of the United Nations Charter, the obligation under the United Nations Charter overrides the term of any party other treaties. Meanwhile, its preamble affirms the establishment of the obligation out of treaties and source of international law. Thank you, sir. Thank you for listening to me.
Assalamualaikum sir, I am Dr. Ahmed Ratna. Today's my presentation topic is treaties as a source of general rules of international law. Now I am talking about my point is general principle of law recognized by civilized nations. Another source of international law is general principles of law. ICJ is directed to consider the general principle of law recognized by civilized nation in its decision making. It means that the ICJ should source for what the legal system of the world have in common and apply those principles. Or rather, should the ICJ use methods and doctrines of domestic legal decision making to the extent that they are useful in addressing the question before the court. to develop an international judicial method. The perfectable view seems to be the international tribunals use domestic law selectively. Their situation are for comparable to make the administration of international law work. Law work. Article 38 includes judicial decision of both international and municipal tribunals. And scholarly written as subsidiary means for the determination of rules of law. In other words, these are not authorities, rather they are advisors of the sources of international law. Thank you, sir. Thank you for briefing me.
Assalamu alaikum, sir. My name is Mohammad Shafqa Hassan, and my topic is treaties and conventions. After signing a treaty or convention, a nation is always free to go it all alone and repudiate all regional or international bodies or refuse to obey the dictates of the United Nations or more broadly and unsettled the community of nations. A treaty is nothing more than an agreement between two sovereign nations. In international law, a nation is usually called a state or nation state. This can be confusing since there are 50 US states, none of which has the power to make treaties with other countries. It may be helpful to recall that the 13 original states under the Article of Confederation were able to have direct relationship with foreign states. Under the present constitution, states gave their right to deal directly with other countries and vested the power in the federal government. There are many treaties to which the United States is a party. Some of these are conventions, which are treaties on matter of common concern, usually negotiated on a regional or global basis, sponsored by an international organization and open to adoption by many nations. This is all from my side. Thank you, sir, for listening to me.
Assalamu alaikum, sir. I am Afia Humaira Ushno and my topic is lawmaking treaties. Lawmaking treaties. Treaty is a common parlance, may be defined as written agreements between parties, which may or may not be stated, to identify and follow a set of rules. The term lawmaking treaty seems to be confusing. It raises the question, can treaties create law? The term actually refers to the content and the subject matter of treaty, which instead of being contractual shall be statutory. The binding force of treaties. Vienna Convention on the Law of Treaties, 1969. The International Law Commission of Nations drafted the Vienna Convention on the Law of Treaties, which was adopted on 23rd May 1969. It is an international agreement between the states to govern and regulate treaties. The treaty is limited to encompasses written treaties only. Divided into many parts, the first part sets out the object, terms, and scope of the agreement, and the second part lays down rules for adoption. The third part deals with the interpretation of treaties, and the fourth part talks about the modification of treaties. General principles. Article 1 of the State Convention says that it is applicable to treaties between the states. It is also applicable to treaties entered into by international organizations. The Convention defines treaty as a written agreement between states, which may be embodied in one or more than one instrument and is governed by international law. Article 2 defines ratification, approval, reservation, etc. In the context of the treaty, it is important to note that none of the provisions of the said convention are applicable to written agreements between an international body and a state. To Two subjects of international law. Role of treaties in international law. Treaties form the basis of international law. They maintain stability and the diplomatic relations between the states. They are the most important elements to guarantee international cooperation, peace, and security. This is one of the reasons why treaties are regarded as the fundamental source of international law. The preamble of the Vienna Convention of the Law of Treaties accords to treaties with the eminent position they hold in ensuring international order and emphasizes their existence as
Assalamu alaikum sir. I am Mohammad Akib Jawad Chaudhuri and my party's conclusion. Treaties are one of the most important sources of international law. These conventions can be multilateral or bilateral. On the other hand, bilateral conventions are those which is formed exclusively by two states to deal with a particular matter concerning these states. Treaties and conventions along with customary international law are the primary sources of what we call international law. A treaty is an agreement between sovereign states and in some cases international organizations which is binding at international law. For the purposes the VCLT, a treaty is defined as an international agreement concluded between states in written form and governed by international law. Whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. Treaties are the principal source of public international law. An agreement between two or more states will not be a treaty unless those countries intend the document to be binding at international law. Treaties can be bilateral between two states or multilateral between three or more states. Thank you, sir. Thank you for listening to me.